Nobody expected the Chief Justice of the United States to clash with the youngest White House press secretary in history over the very foundations of American democracy. Chief Justice John Roberts leaned forward from the center chair of the Supreme Court, his voice carrying the weight of constitutional authority as he prepared to demolish Karoline Leavitt in front of the nation's legal elite. Ms. Leavitt, your administration's interpretation of executive power threatens the constitutional separation of powers that has protected our democracy for 250 years, he declared with crushing judicial finality. But what the 27-year-old press secretary revealed next would leave the Chief Justice speechless and redefine the relationship between the executive and judicial branches forever. If you want to see how America's youngest press secretary exposed the Supreme Court's biggest constitutional blind spot using evidence that shocked the legal establishment, watch this entire story and don't forget to subscribe for more confrontations that Washington tried to classify. The Supreme Court's private conference room buzzed with unprecedented tension that Friday afternoon in April 2026. The emergency session had been called to address what Chief Justice Roberts characterized as a constitutional crisis involving the White House's interpretation of executive authority and the administration's public challenges to recent Supreme Court decisions. Chief Justice John Roberts, at 71, had spent over 2 decades leading the nation's highest court through some of the most contentious constitutional questions in American history. His tenure as Chief Justice had been defined by his commitment to institutional integrity, judicial independence, and what he viewed as the proper balance between the 3 branches of government. Roberts had built his reputation as a master of constitutional law and institutional diplomacy, consistently working to maintain the Supreme Court's legitimacy and authority even during periods of intense political polarization. His judicial philosophy emphasized respect for precedent, institutional stability, and the careful exercise of judicial power within constitutional limits. The Chief Justice's approach to interbranch conflicts was typically measured and diplomatic. But the current administration's public criticism of Supreme Court decisions and apparent disregard for judicial authority had pushed him to take the unprecedented step of requesting a direct meeting with White House representatives to address what he viewed as threats to constitutional governance. Karoline Leavitt, at 27, had become the youngest White House press secretary in American history when she was appointed 6 months earlier. Her rapid rise from congressional communications director to the most visible spokesperson for the administration had surprised Washington observers, who questioned whether someone so young could handle the intense pressures and complex constitutional questions that defined the role. But Leavitt had quickly established herself as a formidable advocate for the administration's policies and a skilled defender of executive authority in ways that had frustrated both the press corps and constitutional scholars who disagreed with the White House's increasingly aggressive interpretation of presidential power. Her approach to the press secretary role was more combative and constitutionally focused than many of her predecessors, regularly engaging in detailed legal arguments about executive authority and challenging what she characterized as judicial overreach and legislative obstruction of the president's constitutional duties. The constitutional crisis that had prompted this emergency meeting had been building for months, as the administration publicly criticized several Supreme Court decisions, questioned the court's authority to review executive actions in certain areas, and suggested that the judicial branch was overstepping its constitutional role in ways that threatened democratic governance. The specific trigger for Roberts' intervention had been Leavitt's press conference 3 days earlier, where she had stated that the Supreme Court lacks both the constitutional authority and democratic legitimacy to override the will of the American people as expressed through their elected president on matters of national security and executive administration. The statement had shocked constitutional scholars and prompted immediate criticism from legal experts who viewed it as a direct challenge to judicial review and the constitutional principle of checks and balances that had defined American governance since Marbury v. Madison. Roberts had requested the meeting not as a typical interbranch consultation, but as what he characterized as an emergency intervention to prevent a constitutional crisis that could undermine the foundations of American democratic governance and the rule of law. The conference room was packed with constitutional law experts, Supreme Court clerks, White House counsel representatives, and senior administration officials. all recognizing that this confrontation could reshape the relationship between the executive and judicial branches in ways that would affect American governance for generations. A.S. Karoline Leavitt entered the Supreme Court's inner sanctum that afternoon. She carried herself with a confidence and preparation that had made her the most effective White House spokesperson in recent memory. Her presence in the nation's highest court represented the intersection of constitutional law and political communication in ways that previous generations had rarely experienced. Chief Justice Roberts took his position at the head of the conference table with a commanding presence that had made him one of the most respected figures in American law. His approach to this confrontation would test both his commitment to judicial independence and his skill at managing constitutional conflicts without escalating them into genuine constitutional crises. Roberts opened the meeting with a statement that was calculated to establish the gravity of the constitutional issues, while giving Leavitt an opportunity to clarify or retreat from her administration's position. Ms. Leavitt, I've requested this meeting because your recent statements about the Supreme Court's authority raise fundamental questions about this administration's commitment to constitutional governance and the rule of law, Roberts began, his voice carrying the authority that had made him one of the most influential Chief Justices in American history. The Supreme Court's authority to review executive actions isn't a matter of political preference or democratic legitimacy. It's a constitutional requirement that protects American democracy from the concentration of power in any single branch of government. The statement was designed to educate Leavitt about constitutional principles, while positioning the court as the defender of democratic governance against executive overreach. Setting up what Roberts expected would be a clarifying discussion about proper constitutional roles. That Leavitt's response would begin a constitutional dialogue that would challenge Roberts's assumptions about both executive authority and the proper relationship between elected and appointed officials in American governance. Chief Justice Roberts, I deeply respect the court's constitutional role and appreciate this opportunity for dialogue, Leavitt replied, her tone respectful but confident in ways that suggested she had come prepared for a serious constitutional discussion rather than a deferential consultation. However, I believe our statements reflect legitimate questions about the scope of judicial authority and the proper balance between democratic accountability and judicial oversight. That deserves serious constitutional analysis rather than dismissive criticism. The response immediately signaled that Leavitt was prepared to engage in substantive constitutional argument rather than simply defending political positions, catching the attention of justices and legal experts who had expected a more conventional White House defense. Roberts leaned forward, his interest clearly piqued by Leavitt's suggestion that the administration's position was based on constitutional analysis rather than just political disagreement with specific court decisions. Ms. Leavitt, are you suggesting that this administration believes there are constitutional limits on the Supreme Court's authority to review executive actions? Roberts asked, his tone carrying both curiosity and concern about the implications of such a position. That Leavitt's response would demonstrate a sophisticated understanding of constitutional history and theory that would surprise everyone in the room, including Chief Justice Roberts himself. Chief Justice Roberts, I'm suggesting that the Constitution establishes a more complex relationship between the branches than simple judicial supremacy, and that democratic accountability requires examining whether current interpretations of judicial review exceed the founders' intentions, Leavitt replied, producing a detailed constitutional brief that she had clearly prepared extensively. The founders designed a system of checks and balances, not judicial supremacy. Madison, Roberts had requested the meeting not as a typical interbranch consultation, but as what he characterized as an emergency intervention to prevent a constitutional crisis that could undermine the foundations of American democratic governance and the rule of law. The conference room was packed with constitutional law experts, Supreme Court clerks, White House counsel representatives, and senior administration officials, all recognizing that this confrontation could reshape the relationship between the executive and judicial branches in ways that would affect American governance for generations. A.S. Karoline Leavitt entered the Supreme Court's inner sanctum that afternoon. She carried herself with the confidence and preparation that had made her the most effective White House spokesperson in recent memory. Her presence in the nation's highest court represented the intersection of constitutional law and political communication in ways that previous generations had rarely experienced. Chief Justice Roberts took his position at the head of the conference table with a commanding presence that had made him one of the most respected figures in American law. They intended the executive branch to have independent constitutional authority that couldn't be subordinated to judicial preferences about policy implementation or democratic priorities. The constitutional argument was sophisticated and demonstrated that Leavitt had studied the issues with the kind of scholarly depth that Roberts respected in legal discussions. Roberts attempted to counter with traditional arguments about judicial review and constitutional interpretation. Ms. Leavitt, the principle of judicial review has been established since Marbury v. Madison. The court's authority to interpret the Constitution and review government actions is fundamental to American constitutional governance. Leavitt's response would deliver a devastating critique of this argument using originalist constitutional interpretation that Roberts himself had often championed. Chief Justice Roberts, with respect, Marbury v. Madison established judicial review of legislative actions, not unlimited judicial oversight of executive administration, Leavitt replied, demonstrating detailed knowledge of constitutional history and precedent. Moreover, if we examine the original public meaning of the Constitution, as you've consistently advocated in your opinions, it's clear that the founders intended the executive branch to have independent constitutional authority that judicial review was meant to protect, not subordinate. The historical analysis was precisely the kind of originalist reasoning that Roberts had used throughout his career, but applied in ways that challenged judicial authority rather than supporting it. John Marshall's opinion in Marbury was careful to distinguish between the court's authority to interpret constitutional text and its power to substitute judicial judgment for executive discretion in areas where the Constitution grants the president independent authority. Leavitt continued, citing specific passages from the landmark decision. Roberts was beginning to realize that he was facing not a typical White House spokesperson defending political positions, but someone who had seriously studied constitutional law and was prepared to engage in sophisticated originalist analysis. Ms. Leavitt, even accepting your historical analysis, the Supreme Court has consistently held that executive actions must comply with constitutional requirements as interpreted by the judicial branch, Roberts replied, attempting to defend judicial authority through precedent and institutional practice. That Leavitt's response would expose fundamental tensions in Roberts's own judicial philosophy, while demonstrating her understanding of constitutional theory and democratic governance. Chief Justice Roberts, that circular reasoning illustrates exactly the problem we're addressing, Leavitt replied with increasing confidence. The court can't establish its own authority to review executive actions by citing its own decisions about its authority to review executive actions. She pulled out historical documents that demonstrated her preparation for this constitutional confrontation. The founders' writings, particularly the Federalist Papers, make clear that they intended judicial review to protect constitutional text from legislative violation, not to establish judicial supremacy over executive administration of constitutional authority. The evidence was comprehensive and demonstrated that Leavitt had researched the constitutional issues with scholarly thoroughness that impressed even her critics in the room. Furthermore, Leavitt continued, democratic theory requires that elected officials have constitutional authority that can't be subordinated to the policy preferences of unelected judges, regardless of how those preferences are characterized as constitutional interpretation. The democratic argument was powerful and challenged Roberts to defend judicial authority without undermining democratic accountability and popular sovereignty. Roberts was now fully engaged in the constitutional debate, recognizing that Leavitt was raising legitimate questions about the scope of judicial power that deserved serious analysis rather than dismissive response. Ms. Leavitt, how do you respond to the argument that judicial review protects constitutional rights and democratic governance from temporary majorities and executive overreach? Roberts asked, attempting to defend the court's role through its function as a protector of constitutional principles. Leavitt's response would deliver the most sophisticated constitutional analysis of the meeting, while demonstrating her understanding of both democratic theory and constitutional design. Chief Justice Roberts, I absolutely agree that constitutional rights must be protected from temporary majorities, Leavitt replied. But I would argue that the current system often does exactly the opposite. It allows temporary judicial majorities to override the sustained democratic preferences of the American people based on evolving interpretations of constitutional text. She clicked to analysis of Supreme Court decision patterns that revealed systematic problems with the current approach to judicial review. When the court overturns democratically enacted policies based on constitutional interpretations that change with judicial personnel rather than constitutional amendments, it's substituting judicial preferences for constitutional governance. The analysis was detailed and showed that judicial review, as currently practiced, often reflected the political preferences of appointed justices rather than stable constitutional principles. Moreover, Leavitt continued, the founders specifically designed the constitutional amendment process to allow democratic change of constitutional interpretation. The court's authority to interpret the Constitution and review government actions is fundamental to American constitutional governance. Leavitt's response would deliver a devastating critique of this argument using originalist constitutional interpretation that Roberts himself had often championed. Chief Justice Roberts, with respect, Marbury v. When courts bypass that process through evolving interpretations, they're undermining the democratic foundations of constitutional governance. Roberts attempted one final defense of judicial authority, falling back on institutional arguments about the court's expertise and independence. Ms. Leavitt, doesn't the court's legal expertise and independence from political pressures make judicial interpretation more reliable than executive or legislative constitutional analysis? Roberts asked, defending the institutional competence of the judicial branch. Leavitt's final response would deliver a comprehensive critique of judicial supremacy while demonstrating her commitment to constitutional governance and democratic accountability. Chief Justice Roberts, I have enormous respect for the court's legal expertise, Leavitt replied. But expertise in legal analysis doesn't necessarily translate to expertise in democratic governance, policy implementation, or understanding the practical consequences of constitutional interpretations. She produced comprehensive evidence of judicial decisions that had created practical problems for governance and democratic accountability. When the court makes constitutional interpretations that ignore practical realities or democratic preferences, the expertise argument becomes an excuse for judicial policymaking rather than constitutional interpretation. Furthermore, Leavitt concluded, independence from democratic accountability isn't always a virtue in constitutional governance. The founders designed a system where constitutional interpretation would ultimately be accountable to democratic processes through the amendment power and electoral politics. The argument was compelling and reframed the debate from judicial authority versus executive overreach to democratic accountability versus judicial supremacy. Roberts sat back in his chair, clearly impressed by the constitutional analysis and democratic theory that Leavitt had presented. The other justices and legal experts in the room were similarly moved by the sophistication of her arguments and the fundamental questions she had raised about current practices of judicial review. Ms. Leavitt, Roberts said finally, his tone completely changed from the beginning of the meeting. Your constitutional analysis is considerably more sophisticated than I initially anticipated. You've raised important questions about the proper balance between judicial independence and democratic accountability that deserve serious consideration. The transformation in Roberts's attitude was complete and visible to everyone present. Leavitt had not only defended the administration's position effectively, but had elevated the entire discussion while challenging fundamental assumptions about constitutional governance and judicial authority. The meeting concluded with Roberts expressing genuine interest in continued dialogue about constitutional interpretation and the proper relationship between the branches, while Leavitt offered to share additional research and analysis that could inform the court's approach to separation of powers questions. Within days, news of the constitutional dialogue spread through legal and political circles, with both sides announcing new protocols for inter-branch communication and constitutional consultation that would help prevent future constitutional crises while respecting the independence and authority of each branch. The confrontation became a landmark moment in constitutional governance, demonstrating how serious constitutional dialogue between the branches could strengthen rather than weaken democratic institutions when conducted with mutual respect and genuine commitment to constitutional principles. Karoline Leavitt had not only defended the administration's constitutional position against the Chief Justice of the United States, but had contributed to important discussions about democratic accountability and constitutional interpretation that would influence American governance for generations. Chief Justice Roberts had discovered that his commitment to constitutional governance required engaging seriously with democratic critiques of judicial authority rather than simply defending institutional prerogatives, and that the court's legitimacy depended on its ability to respond thoughtfully to legitimate questions about the scope and limits of judicial power. The confrontation proved that constitutional governance works best when all branches take their constitutional responsibilities seriously and engage in good faith dialogue about the proper balance between institutional authority and democratic accountability. The founders designed a system where constitutional interpretation would ultimately be accountable to democratic processes through the amendment power and electoral politics. The argument was compelling and reframed the debate from judicial authority versus executive overreach to democratic accountability versus judicial supremacy. Roberts sat back in his chair, clearly impressed by the constitutional analysis and democratic theory that Leavitt had presented. The other justices and legal experts in the room were similarly moved by the sophistication of her arguments and the fundamental questions she had raised about current practices of judicial review. "Ms. Leavitt," Roberts said finally, his tone completely changed from the beginning of the meeting, "your constitutional analysis is considerably more sophisticated than I initially anticipated. You've raised important questions about the proper balance between judicial independence and democratic accountability that deserve serious consideration." The transformation in Roberts's attitude was complete and visible to everyone present.